everyone. I'm Kim Coghill with ACA International in the Washington, D.C. office. ACA is the leading voice for the accounts receivable management industry. The content provided in this podcast is presented for educational and general reference purposes only. The content is not intended to serve as legal advice. Before we get started on today's podcast titled Litigation Landscape in West Virginia, what debt collectors should know about the 2015 amendments to the Consumer and Credit Protection Act, I'd like to remind you about ACA's newest product called All Access Training Zone. This is a members-only exclusive one-stop shop for full access to all of ACA's webinars and webinar recordings at one low price. So please check out our website at www.acainternational.org for more information. Back to today's ACA Cast, which will be led by Carrie Barber, ACA's Corporate Counsel. Carrie's guests today are Jeff Turner, a partner with the law firm Surdyk, Dowd Turner in Ohio, and Nick Mooney, a partner with the law firm Spilman, Thomas & Battle in Charleston, West Virginia. So at this time, I'll turn it over to Carrie.
Thank you, Kim, and thank you, Jeff and Nick, for joining me today for this edition of ACA Cast. You may have seen a couple weeks ago that ACA alerted its members about somewhat of an alarming trend in West Virginia that's likely attributable to the 2015 amendments to the West Virginia Consumer Credit and Protection Act. So these amendments, from my read, they did decrease the maximum per violation amount from the inflation-adjusted $4,800 to $1,000. But Nick, I'm not so sure that it even matters because the class action caps were also amended or introduced to the West Virginia Consumer Act. And as enacted, the aggregate limits on the amount of the $1,000 per violation penalty is applied severally to each named plaintiff and each class member, such that the plaintiff or any class member may not recover in excess of the greater of $175,000 or the total alleged outstanding indebtedness. Nick, can you begin by explaining to our listeners what those amendments actually mean from a practical standpoint and any intel into the precipitating factors that led to those amendments?
Absolutely. Thanks. The first thing to understand is that the West Virginia Consumer Credit and Protection Act, I think it's easiest just call it WVCCPA or CCPA. It was enacted in 1974, and that becomes important for us in a moment. The statute itself tries to mirror the FDCPA, even though it was enacted before, but it really is an animal of its own that's an amalgamation of two model acts. What we find in the act, and this is some of the precipitating factors to the amendment, a couple things. Number one, a lot of ambiguities in the statute. Number two, the penalties. Like you said, we have penalties first off per violation, not per lawsuit. So if you have a lawsuit with 10 violations, you have 10 penalties. And the penalties, as they were first enacted in 1974, were a range. The court could award a penalty per violation from $100 to $1,000. But a later provision says, and the court can adjust that for inflation from 1974, inflation in the Consumer Price Index from 1974. So what you have in around 2015, when the amendments go into effect, is you have statutory penalties that are actually about $480 to $4,800 or $4,900. It changes every month, but that's per violation. A massive amount of penalties that collectors were facing. So that was one of the precipitating factors causing our legislature to take a look at this statute. The other thing, I think, was that we had this massive glut of lawsuits, hundreds and hundreds of lawsuits being filed, probably thousands of lawsuits being filed, and they were focused on two different sections. People are smart, people are creative, and they file lawsuits under a lot of sections, but the two that bubbled to the top were, call them 2128E, and I know that means nothing for folks, so I'll explain it. 2128E and 2125D. 2128E prohibited any communication when it appeared that the consumer was represented by counsel and the attorney's name or address could be easily ascertained. Let me talk about that one for a second. What we saw, and I think what the legislature saw, was a little bit of gamesmanship going on here. First off, courts had held that attempted phone calls were communications. So we had a situation arise here where consumers would answer a collection call, say, hi, my name's Nick Mooney, and they say, yeah, you should know this is going to be recorded. I'm calling you. Consumer would say, I'm represented by blah, 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 and his or her phone number is blah, 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 and hang up, and never answer another call. And every call thereafter was a violation, or could be a violation. Most courts were holding that it was a violation, and every call thereafter could lead to a penalty of $4,800. it wasn't hard to rack up very, very big penalties. A couple of the other things that we saw not where a consumer would answer the phone call and give that information, but I actually saw some cases where consumers would make a payment, like on a credit card, where they put in the envelope a check and a remit stub. And on the remit stub, they would write on the bottom, I'm represented by an attorney, her name is blah, 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 and her phone number is blah, blah, blah. And then they would never make another payment, and they would never answer the phone, and they would just count up every collection call thereafter. We saw a lot of that happening. We also saw consumers who would, when they're being called by either a large outfit with many branches or they're being called by the creditor, they would go to the local branch here in Charleston or go to the local branch somewhere in southern West Virginia and just tell one of the tellers or tell one of the customer service reps, I'm represented by an attorney and his or her name is this and his or her phone number is this, and then they wouldn't call again. That became an issue and it led to lots and lots of lawsuits. The other one that I think was a precipitating factor that bubbled to the top was 2125D, I mentioned a second ago. And what that is, and everyone's familiar with this, what it is essentially harassing phone calls, causing a telephone to ring, or engaging any person repeatedly or continuously or at unusual times or times known to be inconvenient. We all kind of know what that says. But what we saw here that was leading to a lot of lawsuits were, I think, consumers trying to find on the spectrum, sort of thread the needle of what language is going to be strong enough to trigger that prohibition on communicating with me, but not strong enough to actually stop the calls. And a couple courts that said, look, if a consumer says, don't call my work number, that triggers it. Okay, that's no problem. We can all understand that. If we had courts say, look, if the consumer says it's not my debt, then every call thereafter is a violation. Those are easy to understand, but I had cases where, and I think lots of other people had cases where the consumer was saying, I can't pay right now. Well, what does that mean? You know, you're never going to pay again? Should I wait a month to call you? Or we had some where the consumer would pick up the phone and say, please don't call me again, and hang up. So what would that do? Those two sections of the code led to a lot of lawsuits. Those two sections, sort of what I think the legislature saw as the massive amount of lawsuits being filed and the high penalties, led them in 2015 to take a look at the act and say, hey, this has been in effect since '74. We need to tighten up some things. And that's, I think, what led to the amendments.
So just one question about the intel that you just provided was, some of the scenarios, they seem to involve some very savvy consumers, or do you think that some of those consumers were actually being coached by their attorneys or attorneys looking for some work?
I think the attorneys are 100% involved in it. I think they would prepare and give to their clients some written materials about how to answer the phone, and also some blank call log forms where the consumers can fill out their own call logs. And they would have headings. They would look like a chart. And they would have headings for date, who called, what phone number, what time of day they called, what dates they called, what you said to them, did you give them attorney notification, then keep a list of every attempted call thereafter. A lot of times the people had caller IDs, and so it was easy. You know, where the courts were saying that an attempted call is the same as a completed call, purposes of finding a, quote, communication, then having a caller ID does a lot of work for the consumer.
So, Jeff, were there any other amendments in 2015 that perhaps play on the consumer attorney strategies concerning the West Virginia law versus filing under the FTCPA, for example?
Well, I think we're going to talk about a couple things a little bit later, but one of the things you hit on and that Nick mentioned early on was the class action issue, which everyone's used to the 1% net worth in the FTCPA. We don't have that, as you mentioned initially. We don't have limitation. There can be, well, essentially $175,000 per plaintiff, named plaintiff, and per class member. And as far as, the FTCPA versus the next con of the CCPA, they're doing everything they can to keep these in state court. They're pled with state claims, not federal claims, which keeps us in state court. Nick will tell you, and I can tell you when you get there, it certainly is more favorable, not just in West Virginia, but certainly is in West Virginia. Typically, the state court is going to be more favorable to plaintiffs, to the consumer, than it is to a collection agency. We're stuck there the entire time. Even when you have a class action with a lot of potential exposure, we're in state court. We're not in federal court at all, which is, of course, what the collection agencies are used to dealing with federal claims and claims under the FTCPA. Definitely not the same.
And how about the statute of limitations? How does the amendment to the statute of limitations in which to bring a cause of action under the CCPA, how does that play with the strategy for consumer attorneys?
try to argue that it's less in some of these cases, but it's 4 years. We'll go back and say, no, it should be 2 years. It depends on when the cause of action accrued. So you get into that, especially with the class actions. Nick will talk about that a little bit as far as what we argue as far as the statute. But the 4 years certainly drags it out and drags more potential class members into a case.
Are there any actions that members that collect in West Virginia should take to avoid these types of lawsuits?
As you do in every state, but you got to cross all your T's, dot all your I's. Practices, procedures, have your letters reviewed regularly. I think you should adopt and enact some internal controls for limiting your contacts with West Virginia consumers. We hear that from the judges. We hear that from the AG's office there as far as too much contact, too many calls. You need to have adequate procedures in place, and they need to be regularly reviewed. And this includes, we're going to talk about as far as the letter requirements, as far as the out-of-stat language, that would include making sure you're identifying out-of-stat accounts. And a little bit difficult, not just in West Virginia, but definitely in West Virginia, as far as calculating what the statute of limitations is. That can be very difficult. So you don't want to mistakenly think you've got a huge group of accounts that are not out-of-stat, when in fact they are out-of-stat. And when they're out of stat, they need to have the proper disclosure. If you have a large group without the proper disclosure, whether it be beyond the date to sue or past the date of obsolescence, so it can't be recorded to the credit bureau, you have language in West Virginia that's required. You don't put that on your letter. It's a very easy class action to make, but that's a problem, just like it is across the country. A collection of out-of-stat debt being frowned upon. Big problem in West Virginia. We always say, hey, have policies and procedures in place, and a lot of agencies do, but it's important there, not in West Virginia, not just generally collection laws. Specifically address complying with the West Virginia statutes and West Virginia laws. That's asked about very often in discovery. When plaintiffs' counsel serve discovery, they ask very often about policies and procedures that an agency has in place so that they don't violate West Virginia law specifically. And I think that's very important.
Yeah, that's great. Very helpful information for those who need to look at their operations, specifically when it comes to West Virginia collection. Nick, are there any other ancillary laws that members collecting in West Virginia need to be aware of?
Absolutely. I think the biggest one, and Jeff and I have dealt with this a number of times, is the West Virginia Collection Agency Act. That's in Chapter 47 of the Code. What it tries to do is address multiple things that would impact a collection agency's business. What it requires, and a lot of people don't know that the statute exists. It's kind of obscure, but what it requires is a number of things. One, it requires a license. Two, it requires a bond. Three, it requires an office. Four, it requires record keeping. Let me tell you a little bit about each one. It requires collection agencies, which are defined in that statute, the Collection Agency Act. It requires them to have a license. And then it goes on to say, and your business registration certificate issued by the West Virginia State Tax Department is your license. Okay, that's easy enough. It requires the collectors to post a bond. What the statute doesn't say, but what everyone should be aware of, is the State Tax Department's position is that that bond must be approved by the Attorney General. So they'll get the bond, they'll submit it to the Attorney General. If there are any problems, any deficiencies, you'll hear back from them. That's actually not too hard to remedy, easy enough. The third one is office requirement. I'll skip that, come back to in a second, because the fourth one and the last one is record keeping. The statute, the Collection Agency Act, sets forth some record keeping requirements. You have to segregate funds. You have to keep your records. They have to be available. Interesting thing from our standpoint, and what we tell our clients, what the members should know, is that this record keeping requirement talks in terms of keeping records for the clients. So our position is always, and I think it's pretty clear, that record-keeping requirement is not a consumer protection function. It's just for the collector's clients, the creditors. So that is not something that we see coming into play a lot. So I covered 1, 2, and 4. Let me jump back to 3, and that's the office requirement. The Collection Agency Act actually says that you must have an office in West Virginia. Now, you must have an office in West Virginia if you meet the definition of collection agency. And we can argue back and forth whether a certain collector meets the definition of collection agency. I don't think the Collection Agency Act is as broad as my colleague on the consumer bar think it is. I think it's much, much more narrow. So that's a point we always argue. But just talking about the office requirement, it is in there black and white that there's an office requirement. You must have an office in the state. Well, that's interesting because it's been in there for many, many years, but it's never been enforced. I'm not aware of any case where any government regulator here in West Virginia has tried to enforce that. What we've argued, we did have one case where a plaintiff filed a class action on this, saying, yes, great, Nick's client met the license requirement, met the bond requirement, but it didn't meet the office requirement. And because you didn't have an office in this state, you didn't satisfy all the requirements for a Collection Agency Act, you are not allowed to collect in West Virginia. So every phone call you made and every letter you sent is a violation. We fought back on that, saying a lot of things, including the office requirement we think would violate at least the Interstate Commerce Clause and a number of other things. You know, the Interstate Commerce Clause, and I should tell you I'm no constitutional scholar, the Interstate Commerce Clause requires a legitimate government function. And our argument is, and you can see it in the papers in the court file, that it's hard to argue there's a legitimate government function to an office requirement when none of the government regulators here in West Virginia ever seek to enforce it. Pushed back pretty hard on that case. I think we got a really good result. We ended up settling on an individual basis and it went away. It only lasted for maybe a year. Other than that case, I've never seen anyone file suit or any government agency here in West Virginia start any enforcement action and any investigation or anything like that on the office requirement. You know, I think it's an obscure little provision. There is this office requirement statement in the Collection Agency Act. So I think the members should take a look at that or talk with their counsel or someone who can help them understand that statute as well.
While that particular provision, that office requirement statement, is still in there in the Collection Agency Act, it's less used as a basis for a lawsuit. Is kind of what you're saying. But members should be aware that it actually is in there. That's one of the more obscure provisions, like you said. So this next question really goes to both of you. But maybe we'll start with you, Jeff. You know, Nick described several type of factual allegations that are pled in a complaint that lead to an action under the CCPA. What is the typical factual allegations that you two see that people who collect in West Virginia are likely to see in these lawsuits?
We're not seeing as much of the attorney contact because that got revised a little bit. Help the agencies a little bit and the statutory amendments explain some things a little better. Definitely seeing letter issues because those can easily be turned into class actions. We're definitely seeing issues with the out-of-stat language and it not being in the letters, as well as allegations that fees or interest are improperly being added to accounts. As always, recommend that the agencies make certain that they can add the fees or that are added on there, or the creditor can. Where are they coming from? Is there a contract that specifically provides for these to be added? And is that legal in West Virginia? Is it proper? Is that okay in West Virginia? It's extremely important and can turn into a big, expensive class action mess, certainly in West Virginia and elsewhere, but definitely there now that we're seeing a lot of class actions.
Nick, did you have anything to add to that?
I think Jeff hit the nail on the head. I mean, that's what we're seeing, and the point he made, I'll underscore that. What we're seeing are claims that are letter-based and claims that apply across the board to all debtors that are more easily turned into a class action. So we're seeing a lot of that, fees or interest, what you can charge, what you can't charge, 100%. We're seeing that. Statute of limitations claims, collecting out-of-stat debt without the time-barred debt disclosure. We see that a lot now, and they are pled as class actions. I want to emphasize something that Jeff said a few minutes ago. I 100% agree with it. It's difficult to determine what statute of limitations applies to the debt you're trying to collect. You have to be very, very careful there because we do have multiple sources of authority in West Virginia that might impact that. We do have statutes that will spell out statutes of limitations for certain types of debts, but we have case decisions that have addressed the statute of limitations for other types of debt. We have a borrowing statute in West Virginia that says if a cause of action accrues out of state, the lesser of West Virginia and the other states' statute of limitations applies. So that's a wrinkle that you have to take into account. We're fighting that issue right now. So yeah, I think Jeff hit the nail on the head, and I would just underscore statute of limitations seems super easy to understand. It is not. And you have to be very, very careful there to make sure you know what statute applies before you start collecting.
Seems like collection agencies might be baited in the state of West Virginia by consumer attorneys or otherwise Are there any sort of safe harbors or right to cure laws in West Virginia that members can seek or be on the lookout for?
Absolutely. The first thing I would tell them, the primary one is we now, as of 2017, we have a new pre-suit right to cure notice that applies generally to the WVCCPA, the entire statute, which encompasses the debt collection provisions. There was a pre-suit requirement tucked away in Article 6, but it only applied to things in Article 6, which is not usually debt collection. But we now have a requirement that's entitled right to cure, and what it requires is a consumer to give the collector a written pre-suit letter that meets some requirements. It has to be served by certified mail. It has to be served on the registered agent. It has to provide the alleged violation. You explain the alleged violation and the factual basis for the violation. The statute then gives the collector 45 days to make a cure offer. Hey, I got your letter. I see you say we violated XYZ. We'll offer you $2,000 to get rid of it. Collector gets 45 days to make that cure offer. The consumer then gets 20 days to accept it. There are a couple things I think are important about this, and Jeff has dealt with this as well. First off, we have that safe harbor provision. It hasn't been, I don't think, terribly effective because almost all, if not all, the pre-suit letters that I get, that's probably not fair. I'll say most of the pre-suit letters I get are very, very vague. They're just saying, you violated the WVCCPA in a number of ways, including but not limited to blah, 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 and that's it. And it puts the burden, improperly I think, it puts the burden on the collector to come forward and give some pre-suit discovery. Hey, Mr. Consumer, I see you said we violated this by calling you after attorney notification. Here are our records. We only had 2 of those calls, so we'll give you $3,000. You know, what I'm finding is my clients are saying no to giving pre-suit discovery. They don't want to give it. So we'll get these very vague, very general pre-suit letters that maybe comply with the statute, maybe they don't. They don't go anywhere. We can't do anything with them. Even though these might not be effective, I still think the collector wants to insist on them being given. I've had cases where consumers filing the lawsuit and we move to dismiss saying you didn't satisfy this, you never sent me a pre-suit letter. And we've had judges say, you know, what's the matter? We're here now. If you want to settle the case, you could settle it, but you didn't settle it, you know, between the time you got the complaint and this hearing, so no harm, no foul. And my position is always the same. No, because the statute makes this a very important requirement, because if we give a cure offer and the consumer doesn't accept that cure offer, but the consumer then pushes this thing to trial and doesn't recover at least that amount in actual damages and penalties, then my client's not liable for the consumer's attorney's fees. Attorney's fees, we all know, are a big driver in these lawsuits. So I think that statute has to be complied with. It's only right. It's in the code for a reason. So I always push it to be complied with. I think our collectors, our members should know if they get a complaint, the first thing I would do is look through your system for that consumer and say, hey, did we get this required 5108 pre-suit notice letter? And if not, I think that's the first grounds to defend this thing on.
So, Jeff, you know, in light of what Nick was just talking about with the right to cure and the requirement for it, are you seeing more cases settle, or are you seeing more cases litigated to trial, or are these usually disposed of at a dispositive motion? How do you typically see these cases go away?
I think, like every other jurisdiction or most jurisdictions, most of the cases are certainly being settled short of trial. In some cases, we certainly have arguments and make those in dispositive motions. Oftentimes, unfortunately, they languish in state court because that's typically where we are, and they sit there for a very long time with no ruling, and then the scheduling order put in place, and then we're, ordered to mediation, arbitration, something, just in the hopes that something will get resolved. Nick said, I just think the right to cure hasn't really changed a lot. Hopefully it does. It really doesn't seem to be changing anything. I would just be cautious and warn everybody, when you get one of these, and Nick mentioned it, be careful what you provide in response. I think typically the knee-jerk reaction is for the agency to write something back to the plaintiff's attorney and say, oh yeah, we may have done ABC wrong, but we're a very small agency, so this isn't going to be worth your time and effort going after us. They don't care. It doesn't make any difference to them. And then we provide all this information, and it gives them more than they ever had to start with. So I think you have to be very careful that you think you're going to convince them to go away by responding and saying, hey, we didn't do anything. Certainly, there's nothing wrong with responding and saying we didn't do anything wrong, but I just think you have to be careful what you do in response to that and what you provide them as far as information and certainly documents. But I think courts are definitely pushing the cases more towards resolution than they are toward trial.
So I'm going to stick with you for just a little bit longer, Jeff. So specifically from an insured or insurer's perspective, what sort of proactive steps should collection agencies take with their insurer in anticipation of lawsuits coming up in West Virginia for those who actually are collecting in West Virginia?
Make sure you're covered. Certainly make sure you're covered for your collection activity. I mentioned before, be very careful about what you're collecting in the way of fees and interest, anything like that. If that's an element of damage, that's typically going to cause you insurance issues, coverage issues from the standpoint of disgorgement. So be very cautious. Just ensure you've got coverage for what you're doing there. And be careful. Make sure you're disclosing your practices. What am I doing there? And is this part of what I have coverage for? And this is extremely important. You don't want to find out you've got a problem after a lawsuit comes in. You want to find out you've got a problem that you can remedy before you get the lawsuit in.
Great, thanks. And then, Nick, do you anticipate this sort of a trend, the class action trend, to continue, or do you have some prediction that maybe the West Virginia legislature will step in again to remedy this issue, or whether they see it as an issue even?
Going back to something that Jeff said a moment ago, we're still seeing some individual actions, but I think the trend toward class actions is going to continue. It's just a lot more lucrative for the consumers and the consumers' attorneys, so I think we're going to see more and more of those. The other thing that I think plays into this is the framework and the governing law that courts look at when they're determining whether to certify a class action. Plaintiffs file a lawsuit, it's a putative class action, it's a purported class action, but then it takes the court to certify it, and the court looks to a number of steps and a number of factors to determine whether it will or will not certify the case to go forward as a class action. So in West Virginia, we have some pretty flexible framework on what courts are to consider. One case in particular is our seminal case, and it really puts a lot of discretion in the court's hands to certify things as class actions. That case has been around for a number of years. But one of the things that just came out earlier this year was another case that actually is starting to contract that a little bit and saying, well, hold on a second. It's not just, Wild West free-for-all, everything gets certified as a class action. So I think, to answer your question, I think we're going to continue to see more and more class actions be filed. I 100% agree with Jeff that more get settled than ever get tried. I don't anticipate seeing the legislature changing the CCPA to do something as drastic as preclude class actions. I don't think that's going to happen. There may be an amendment in the future that places another limit on class action damages, sort of the 1% of the collector's net worth. But I think what we'll see, if we see anything in the tightening up of the class actions, I anticipate seeing that from the courts, coming down with decisions saying, no, this can't be a class action, no, that can't be a class action. And so we'll have this sort of tightening up of it on a one-by-one basis, sort of an ad hoc basis.
So we did cover a lot of information. I know I learned a ton from this conversation, but I want to make sure that, for the benefits of our members and those collecting in West Virginia, that there isn't any other piece of information that either of you think that our members should know, that we need to get out there about any sort of pitfall that may occur with collecting in West Virginia. So, Jeff, why don't you start if there's anything else you wanted to cover?
I think we've covered everything pretty well. I just think, you need to be careful. As I will happily tell agents and agencies, and Nick and I have discussed this before, be careful when you're collecting there. If you only have a few accounts, I don't think it's the state to dabble in, if you want to call it that. I would make sure it's worth your effort to go there. And if it takes having a conversation with your client, with the creditor, then I would do that, because Nick mentioned earlier, sometimes we see the creditors sued. It isn't just collection agencies, it's creditors also. I just think you have to be extremely cautious what you're doing there, and again, regularly have everything reviewed, your letters, your policies and procedures. Nick talked about licensing and registration. Make sure that gets updated when it needs to get updated, and then renewed when it gets to be renewed. You can have the best letter and the best practices in the world, but if you don't have the proper registration or licensing, you're going to have a problem, and it's probably going to be a class action.
And Nick, what do you have to add?
I would just add some good stuff. We've talked a lot about some serious things and some bad things and some doom and gloom, but I'll add a couple positives, sort of taking us full circle back to the 2015 amendments. There are some positives that came out of that. The first one, I think the biggest one that has an impact is there's still statutory penalties per violation, but it's not adjusted for inflation from 1974, adjusted for inflation from, I think, September of 2015. So we're not talking about $4,800 per violation, $4,900 per violation anymore. We reset the date from which any penalty inflates, and that's good because that translates to dollars and cents. So I think that's a positive thing. There are two other positive things. We talked early on about calls after attorney notification and some of the things that we saw here at Spilman on what qualified as attorney notification. Well, the 2015 amendments really tightened that up. Now the notice of attorney representation has to be in writing. It has to be sent to the collector's registered agent or its principal place of business. The collector gets 72 hours to put processes in place to stop collecting. We now have an explicit statement in that part of the CCPA that monthly statements and other required disclosure or correspondence that we're required to send to consumers are not violations. It wasn't clear before, and people were getting tagged with liability on that before. Also, the notice now talks in terms of being represented with regard to the subject debt, so I think it's debt specific. The other thing I would talk about is there's been tightening up of what amounts to harassing phone calls. That what I called 2-125 before, it was a free-for-all and there was no parameter in it. Now the statute is clear that unless the collector has reason to know otherwise, 8 a.m. to 9 p.m. is not inconvenient. That's not a shock to anyone, but it was missing from our statute until 2015. The other thing is we have call counts now, and we've had them since 2015. The harassing phone call statute, this 2-125, says collector can attempt up to 30 calls per week or 10 conversations, or have 10 conversations per week without it slipping into harassing phone calls. So I think the 2015 amendments brought some positive changes with it, and I would want our members to know that.
Great. Thank you for shedding some light or silver lining on this particular statute, because it does kind of seem a bit doom and gloom at the outset, but you're right, there are so many positives that did come from that as well. Thank you both for sharing your insights and your expertise in this particular area, specifically on the West Virginia Consumer Protection Act. I appreciate your time, and I think we'll go back to Kim at this point.
Thank you so much, Carrie, and Nick and Jeff, thank you for all the great information. So before we close today, I just want to remind everyone that registration is open for ACA International's Fall Forum and Expo. This year we will return to Chicago at the Drake, and this will be November 6th through 8th. So thank you so much, and this podcast and ACA's other podcasts are available on ACA's website or wherever you normally listen to podcasts. Thank you and have a great day.